Hello, Joseph.
Hello, how are you?
Good. How you doing?
I'm doing very well. Doing very
Good.
well.
Good, good, good.
You hanging in there at home?
I am trying to absorb as much as I can.
Yeah, that's
So
good. That's a
we had
good.
a good class yesterday with Josh Burnett from up
Yeah,
in Charlotte area. So that was really good, winning the buyer.
good, 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 good. That's a great class. I
It
have
is.
not been to it with Josh yet. He's a newer instructor for CES, but I'm hearing great things about him. So that's awesome.
It was a really good class, and we covered a lot. And it was perfect
Good.
for me because, not having gone on any appointments yet or anything, he went through the whole step from the lead right up to the, getting it, signing the paperwork and everything like that.
Yeah, yeah. Well, cool. Good, good, good. Today, depending on who shows up, I'm gonna do possibly a little more of an open forum. If it ends up just being you and I, then that's great. We can go through the contract,
Okay, good.
which will be a good thing. And if it ends up being a smaller group, we can do that as well. Just kind of want to
Hmm.
see who shows up. And we had a webinar yesterday with the brokers in charge across the state with some things to keep an eye on. Nothing real major right now. There's no new forms coming out, which is interesting. I'm kind of surprised at that because most other states are. But instead of doing that, they're really just kind of saying change up protocol in different parts of the contract more
Hmm.
than anything. So,
Now, when you went out with with buyers and trying to get them sign up, um, on the disclosure agreement, did you
mhm.
really explain that good and thoroughly to the customer? Or
um, I mean, full disclosure, when I worked with buyers, I probably could have done it a little bit better.
Mhm.
I would kind of summarize, depending on the personality,
Okay.
would just simply say, hey, just so you understand the different types of agencies are exclusive agency. It's a little bit different now with transaction broker because honestly, if they don't sign something with you by default, you become a transaction broker,
Hmm. Oh,
which is,
okay.
and so you just basically say this is not obligating you to anything. This is simply acknowledging that I've explained the different types of agency to you.
Okay.
So
Yeah.
that's it's, and now honestly they have to, it's a little bit different now because in the new buyer agency agreement, and in the new listing agreement, it states specifically on there that you have explained that to them.
Hmm.
So you do have to have that when you fill it out. I think where we kind of, we don't, the law says it has to happen within the first substantial contact, which
Right.
is incredibly vague. Uh,
Mhm.
um,
Yeah.
so what does that really mean?
Yeah.
So technically that could be your first conversation, but it's hard in a society where people are, we're kind of in a culture where people are less and less willing to sign things right away, yet we're getting protocol that's asking us to do so.
Right.
So it's a little bit interesting.
Well, at least on the
Um,
form, that big block right on the bottom, this is not a contract. It's just that you've been made aware of something.
yeah, and plus only one person's initialing it anyway, so it's not like it's a binding one. Of course, it's them initialing it, so if if you initial it when they walk away, I guess could be their only fear, but that would be kind of silly. So,
Yeah.
all right, let me do a couple things really quickly. Have you when I taught this a couple weeks ago to that class, the track class? I think that was. Oh,
I think maybe the internet's going a
are
little
you
bit.
there?
Yeah, you're getting choppy.
All right, better.
Not yet. Your face is still frozen.
Hold on 1 second. Okay, hold on 1 second.
I'm almost surprised
All
the
right,
whole
how about
internet.
now?
That sounded better.
Okay, so it may be coming back now. I switched wireless ones. Um, do you have me now?
I have you now, but your face
All
is still
right,
frozen. I don't know,
okay.
but I can hear you at
Here
least.
is what I'm gonna do. All right, yeah, my computer's. All right, hold on one. All right, you said you can hear me. Okay.
Not now. I'm hearing nothing now. So I don't know if you can hear me.
Okay. Yeah. Okay.
Hey, Wayne.
Now,
Hi, Jenna.
are you hearing me?
Yes.
Yes, I can hear you now. He was having some trouble. It was going in
Okay.
and out.
Yeah. Yeah. How about now? Is that better?
Yes.
Okay. All right. Something's going on this side. What I'm going to do, I'm going to go ahead and turn off my video because I'm about to switch to the screen anyway. So that'll hopefully help some of the bandwidth. Hi, Jenna. How are you?
I'm doing good. How about you?
I'm doing very well. I'm doing very well. All right. So let's do this. I'm going to change some things up here. Let me find my to-do list. Anything in particular while I'm looking this up, anything in particular that you guys have questions for right now that you want me to cover?
Everything. So I don't know.
That's what I said. Just going through it, just going through the contract form and making sure we're not, like, even what's the order? Like, I know we need to do disclosure first, and we were just discussing that a little bit. But then, like when we're going on the listing, have the contract ready and,
right.
or we legally, because the last thing we want to do is get you in trouble.
Right.
What do we need to cover?
Okay. Perfect. I saw Betsy on here. She may have jumped off, but all right. So let's talk a little bit about that. So there's a checklist that is, I think in one of your onboarding that'll have kind of all of the contracts that you will need in each situation from a buyer side and from a seller side. So the best thing to do on that would be to get familiar with it. And I'll make a note to make sure I email that to you, or I'll email Kristen to make sure she can point you in the right direction of where that is.
Mm-hmm.
So we'll start with a listing agreement. So when you go on a listing presentation, the documents from the state that need to be signed are obviously the listing agreement. You also have the agency disclosure document.
Mm-hmm.
And then you have, if the home was built prior to 1978, you would have lead-based paint. And then if they were filling out, which 9 times out of 10 they will be, the property condition disclosure. So those are your big ones from that standpoint. And then in addition to that, you may have some other things that you have on there. There are some required documents that you have to have into the upload into your opportunity. However, as far as the state documents, those are kind of the basic ones.
Mm-hmm.
Now, just from a protocol standpoint, when you go on a listing presentation, me personally, I only carry the listing agreement and the agency disclosure. If they're going to do the property disclosure or lead-based paint or anything like that, I have them do that in a follow-up after the listing agreement's signed. I like having the physical listing agreement in my hands when I leave. So that's why I do it that way.
You have them fill it out.
Buyer agencies.
Sorry.
Say that again?
Do you have them fill the physical one out and then you enter it in later?
No, I'll send it to them electronically.
Okay.
Or are you talking about the listing agreement?
Yes.
Yeah, I have them physically fill it out and sign it, and then I basically scan it in at that point.
Okay.
So I'll have all mine are scanned in. And again, that's just over time in enough listing presentations where you get a verbal agreement, the listing agreement later. A lot of things can happen, right? So for me, it's just a comfort of leaving there. Plus, I can start away.
Mm-hmm.
Does that make sense?
Yes.
So I can start any of the marketing and everything right away because I actually have the listing agreement. So that's on that one. The buyer side, same thing. You have your agency disclosure, you have a buyer agency agreement. There's really no additional documents at the time that they need. It all goes into the contract after that.
Mm-hmm.
Okay. So what I want to do, based on who's in here now, I want to go through the actual per agreement, because that's really where the most questions will come from, particularly now. And I'll use the same format as I do before. However, I'm going to probably skim through some things quickly so I can get to the things that we really need to be focused on right now with everything that's going on. Just to kind of do this in segments, and then, you know, we'll probably do this more frequently because of the format now and make it a little bit easier. So let me pull up. All right, let's see. I should be able to. All right, so right now you are seeing the contract agreement, contract to buy and sell real estate.
Yes.
Okay. All right, let me actually, here's what I'm going to do. I'm going to change the sharing of this.
So were you just on zip forms?
I was.
Okay. I just signed up and got into that this morning. So
let me pull up the ones that I have. I'm going to pull this one up so it's a full screen. Okay. All right. Bam, bam, bam. Okay. So now you see it's a little bit easier to see on this one.
okay. Yeah. For a minute there we had nothing.
Okay. Perfect. All right. So through this and just talk about right now what to keep in mind and some things that have come up here in the last 24 to 48 hours based on what I'm hearing. So when I pull this screen up, can you guys see what do you see right now on the screen?
The contract.
No.
Just the contract?
Yeah. And the page is on the left side, the layout on the left side, and that's it.
Okay. Okay. Perfect. All right. Because I'm pulling up my checklist to go through here. I want to make sure I don't. Okay. All right, so really on this first part, fill in the blank, buyers and sellers. This is going to be something that you can get off of the tax records. However, this can be amended as it goes. You can find out a lot of times you get as seller side things. It'll have, you know, Joseph Klosik, and however, that was when I bought the house. And after I got married, I added Lynn to the deed, and it never got updated on here. So a lot of times you just want to make sure that you can verify this with the listing agent if you're representing the buyer, or if you're taking the listing. You know, the best case scenario is that you go in and you have a copy of the deed to have that on there. However, the tax records in the MLS is the best place to start. Where you don't want to start with something like TBD or anything like that, at least make some effort so you have a name in there just to keep it cleaner in the long run. Again, because, you know, just to stay on kind of the important parts right now, I won't go through each line, but C under closing attorney, this is, you know, it's great to have this filled out. This doesn't necessarily have to be filled out for a ratified contract, right? This is basically who the buyer wants to coordinate the transaction with. This does not obligate the seller to use the same attorney. So you represent the buyer and they're going to use Butler and College. The seller doesn't necessarily have to, and then vice versa. If you represent the seller and they come in and they want to use Weeks and Irvine, your seller is welcome to use whomever. It doesn't also mean that it's the same person that's holding the earnest money. It's two separate things. So this is just who the closing attorney is. Okay. Again, the rest of these are just kind of definitions. And again, we'll do a more like in-depth one. I just want to kind of cover what we're seeing right now, what's going on. Obviously, this is what Wayne and I were talking about earlier. This is obviously where they initial that they have seen the disclosure of real estate relationships. Purchase price is in here. You technically, how it's written, the $ here, all you need is a number. I always say put the actual verbiage with the number in parentheses or vice versa. It's always best to have both. Keep in mind, if it does have both and you're negotiating, that you counteroffer both of them. You strike and change both of them. So if, you know, it says $100,000 and then has 100,000 in parentheses, make sure both of those get changed. Make sense?
Yeah. Yeah.
Okay. Property, this describes the property. Now, one of the things that's interesting about this, I got to move it over a little bit so I can see it with my screen. A couple things that are important about this contract, about this part of the contract on both sides. Number one, it's saying that the seller, just one thing I want to point out in this, we haven't talked about before, that the seller agrees to maintain the property in operable condition, including landscaping, etc., with the exception of normal wear and tear between the effective date, which is when you ratify the contract, and then obviously the date of closing. So that's just something that you want to keep in mind, particularly if you've got an out of area seller. If it's a investment property where they've had tenants or anything along those lines, you want to make sure that you explain to them that it is still their obligation to maintain the property. This is the other area, the second part of this, that where we tend to get into a little bit of trouble, is that but when they sign this, the buyer has acknowledged that they've already had the opportunity to inquire about any homeowners association, any issues with the common area, master deed issues, or anything like that. Here's where here's where it can get tricky, is if you don't know as a buyer's agent, if you're going into an area that you know, and this really is more for condos and townhomes, but really starting to kind of become a little bit of an issue with single family homes too, is if you're not positive on whether or not there are any issues with the condo deed and everything, you should, or the association, it really does behoove you, unless you're doing due diligence, which we'll come back to. Unless you're doing due diligence, though, you really need to do it ahead of time. Because if you do repair procedure, or you do as is, well, as is negates it, but if you do repair procedure, and then you get into the contract and you find out, oh, there's a $10,000 assessment to purchase in there, that assessment is not covered under the repair procedure. And it's not a reason for your buyers to get out, because what this paragraph says here is that they've already had the opportunity to get out, to review those, and they should have known. Okay, so just something to keep in mind. It doesn't happen often. However, it is something that we need to keep in mind from that standpoint. The next question always is, okay, so where do we get that information? So the best thing would be is they should have contact information of the HOA on the property disclosure. If they do not, then you can reach out to the listing agent to get that contact info. 90% of them are easily Googled, and probably faster. Okay. Now, this does not have anything to do with what they're called, like contribution fees or anything like that. This has to do with any outlying issues that maybe had, like I said, like assessments, anything like that. Okay. The contribution fees and all of that are addressed a little later in the contract. Sound good?
If you call the HOA or get in touch with them, do you try to, and they say, no, we have nothing coming up, there's no assessments right now and nothing coming, do you try to get them to send you an email to confirm that, so you have it right?
And normally they'll have I'm absolutely drawing a blank. They won't send you anything formal because they do that for closing, and that's when they'll charge you. But normally they'll either have a form that states, you know, the association's in good standing, or there are no outstanding issues.
Okay.
Worst case scenario, you get an email though that states, hey, per our conversation, or you can send them an email and say, please reply in the affirmative.
Right. Okay.
All right, so let's jump to paragraph 4. The rest of paragraph 3 is just kind of the legal description. Paragraph 4, I do want to talk about this because right now the big question is, you know, here's where the closing date is marked in here. There are no stipulations right now as it relates to what we're currently going through. So, you know, if closings get delayed or anything like that, you have to have an addendum that addresses that. So if something comes up and, you know, whatever reason, the bank says because of this, the courthouse closes, there's a delay in the deed, yada, yada, yada. There's nothing to say that it can't be extended. However, it doesn't automatically get extended. Now, the argument would then become, okay, let's say the buyer, you know, is getting cold feet and they say, well, because of the coronavirus, I want out. Well, technically there's nothing that says in the contract they can. However, what could happen is if there then becomes a delay, they can say, well, I don't agree to extend it. That's kind of the gray area we're wondering about right now, right? Is what then comes from that. We're not seeing any yet. We are seeing a couple though, where only one in our office right now that I'm aware of, where the buyer has said, we're out, we're freaking out about the situation and the instability. So we went out, here's your earnest money. I mean, they're not trying to fight it for anything like that. Like I said, it's one out of the, you know, quite a few we have pending right now. I would say that from a closing and possession, you know, what that closing date looks like, I'm not hearing anything right now that needs to be extended an abnormal period of time. I'm not hearing that there's really a delay in the closing as it relates to financing or anything like that. The only thing that we're really talking about right now, adjusting timeline wise, is inspections and stuff like that. So we'll talk about that when we get to that part. But for now, it's really the best thing to do here is communicate with the listing agent and the seller, and communicate with the lender.
Okay.
So that way,
Deeds, are the counties recording the deeds now, or is that on hold?
they are still recording now, but
Okay.
it's also being done on a limited basis, so it may take a little bit longer. South Carolina Association of Realtors is working super hard right now to expedite a lot of those services. For instance, they've got a bill that they're trying to get passed right now that allows electronic notary, that's going to allow electronic filing, a lot of these things to help prevent, to honor the social distancing, as well as not delaying the actual transaction
That's
itself.
good.
Yeah. So right now, I mean, everyone's working super hard to make sure transactions go forward, because if the buyer and seller still want it to happen, there's really no reason why we shouldn't do everything we can to make it happen.
Yep.
Okay. Earnest money. So this is what's getting interesting right now. So earnest money is basically, I promise to perform on the contract, right? This is not a fee for termination or anything like that. There's a whole lot of stuff going on around about earnest money right now. The first one is whether or not, particularly with what's going on right now, earnest money should be deposited at the time of contract, or if you should wait until later in the transaction. For instance, let's say you submitted an offer today, today's the 25th, and you gave them until next Friday for due diligence. Some are saying on the buyer side, put in the contract right here, the same date for the earnest money to be turned in, because that way you don't have to worry about a dispute of earnest money during due diligence, saying, hey, we're having due diligence. There's not really a point of having earnest money till we get through it. So we'll turn our earnest money in next Friday as well.
What do you think about
As a listing agent, huh?
what are your thoughts on that?
As a listing agent, I don't love it.
Right.
However, if it's due diligence, it's due diligence. There's really nothing that can come up during the due diligence period where the seller would really have cause for the earnest money. Personally, when I sit with a seller and I say, hey, good news is we got a contract. The other news is it's due diligence. And what that means is during this time frame, literally, they cannot like the way that a picture is hung on the wall and say, I don't want to buy the house. And there's absolutely nothing you can do about it. Right now, that doesn't mean you can't have a termination fee, which is addressed in the due diligence section of the contract, which we'll talk about. However, from an earnest money standpoint, there's some talk about this. Now, the reasoning is because everything is delayed right now, why have the earnest money turned in where you then have to go through the process to get it released, when really if it's released during due diligence, it's released during due diligence. I get it from the buyer's agent standpoint and the buyer standpoint. I don't love it, but I also would understand it if I got it on one of my listings right now. Now, again, that's just for due diligence. For repair procedure, absolutely not. I want the money in the bank before repair procedure, because we still have a lot of gray area on that, which we'll get to.
So on this line here, let's say we're doing $1,000.
Mm-hmm.
So total $1,000 earnest money is paid as follow. $1,000 accompanies this offer then. So if you're doing it right now and it's not due diligence, you'll take it now and you want it now when this is signed.
Right.
And so I am representing the buyer.
Okay.
And they're going to make out this $1,000 check.
Mm-hmm.
Who are we making it out to?
So it will be held by an escrow agent. We do not hold it as Keller Williams. We stopped doing that a couple of years ago, thank goodness.
Okay.
So what most people are doing is the attorney that the simplest and cleanest is for the attorney that's actually going to be the closing attorney. So that goes back to page 1. If your buyer already knows they're going to use Butler and College, then have Butler and College hold the earnest money.
Okay.
Here's the other reason it's good to have an attorney hold the earnest money now versus a real estate company is the attorney is regulated a little bit more. I'm going to risk it and bring the video back on just because I like the interaction better. So the attorney's regulated a little bit more differently than the real estate agent and real estate companies are. I'm freezing up. Hold on. I'm gonna stop it. My internet started yelling at me when I put the video on. My internet started yelling. Maybe it's a sign. The internet's like, just do away with the video for a little bit. So with the earnest money being held by a real estate company, I can only release it by a court order or by a signed agreement. Whereas, and I can't draw up a different agreement with everyone. Whereas an attorney, Butler and College will have what's called an escrow acknowledgement or an escrow agreement form that they'll have with your buyer that says you've turned it in here. Here's how that works, right? So that's why it's better for the attorney to hold it, because when the attorney's holding it, then they can use a little bit more of their discretion on it being released.
Mm-hmm.
Okay. So, but back to your question, the easiest one would be whoever the buyer's attorney is.
So if this was Butler and College, then we would put that on that next line down there.
Correct. As the escrow
Right,
agent.
Butler and College as the escrow agent. So the check then is made out to Butler and College?
Yes.
Okay, so not the seller, just Butler and College. Okay.
Correct. And so to clarify too, this doesn't change your obligation in license law. So let's go to you're working with a buyer, they ratify a contract and they give you the check that say that you're going to bring it to Butler and College.
Right.
My recommendation is that you have them send it directly to Butler and College or take it directly to Butler and College. That being said, license law says if you're handed earnest money, I think the description is immediately you need to turn it into the escrow agent or your broker in charge.
Right.
You wouldn't want to turn it into broker in charge because it's not made out to us.
Mm-hmm.
So you would just want to immediately have it delivered to Butler and College.
Okay.
Okay. Now,
is Butler and College basically the firm that we want to use for the West Ashley office? So we have a relationship with them?
it is. And it's not to say you can't use any other firm. There are plenty of great firms out there. But yes, it's the one we have a partnership with. We personally use them for our business. We use them for our personal transactions as well. They're a great firm. We use them on all of our seller side representation as well.
Okay. And where are they located?
So they have an office on the third floor of our building.
That makes it easy.
Yeah. And then there's one across the street from the Mount Pleasant, Keller Williams, and then they have one in Somerville. Yep.
Okay, great.
So for instance, with what's going on right now, technically, we can't go to a closing at their West Ashley location as the agents, but we can go to closing at the Mount Pleasant location. The ordinance is going on with the city. Now, whether or not it's a gray area, not a great example because it's technically a legal service to a contract with which you're affiliated. But that's a good thing of having the different locations across the area. Typically, we close in whatever one the buyer is most convenient to the buyer or seller. And they work in a way, for instance, we have we had a closing in January. We represented the seller. The seller was in Mount Pleasant. The buyer lived in West Ashley. They went to the two separate offices because they were more convenient for the same closing. So yeah, it's just they're really they work really well with all the situations.
Okay.
And they're really sharp attorneys too, so that's good. All right. So the other thing about earnest money that was brought up too was, if you do get into an earnest money dispute right now, and this really doesn't apply to our office that much because we communicate really well. If you do have the earnest money, if you have a dispute, come to me, right? Even if I'm not the escrow agent. They're really encouraging from the state level right now that we do everything we can to work out earnest money disputes. Because right now, the magistrate courts basically are not going to be reviewing any earnest money disputes. They're just not. It's not. I don't know how they're labeling the prioritization of the service that the county provides, but they're not looking at earnest money disputes right now. That doesn't mean that it's a get out of jail free card for earnest money disputes, because what will happen, and the attorney for the Association of Realtors said this yesterday, what will happen is if you make no effort to solve it, and then fast forward, they finally start getting things back on the docket May 1 or whatever it is. Well, first of all, they got a backlog. So then they've got to catch up with that. And then when they get to yours, if we've made no effort to resolve the earnest money dispute, that's not going to go over well with the judge. So they're just saying right now, do everything you can to solve the earnest money disputes, because first of all, it's probably going to be 6 to 8 weeks before they review them anyway. And then in addition to that, they want to make sure we've done everything to resolve it. Go ahead.
What do we want for earnest money percentage wise, or is it like $500? Like what's the typical?
It depends on who you are. So as a listing agent, I want as much money as possible. As the buyer's agent, I want as little money as
Right.
possible. Typically, you're seeing around that 1% mark up until about $5,000, and then you don't really typically see much more than $5,000. It depends on the situation.
Right.
Now, there are some agents, some in our office, who are pretty big sticklers on making sure they have a giant earnest money check. The contract, every time it's rewritten, gets clearer and clearer on how to distribute earnest money. And quite honestly, at the end of the day, it's if someone's going to default on the contract, the earnest money is not the issue. There's a bigger issue to it all. So, Lynn, with her buyer side, she's typically $1,000 or $3,000, depending on the price point. Typically, is not much more than that. Me on the listing side, it just depends on, you got to take the whole contract and the contract as a whole on what it looks like. I do like to see 4 digits in there, unless it's, just a very low price property.
Right.
All right. So the bold part of that paragraph basically just talks about a lot of what we had, and really only actually applies if we're the escrow agent that's holding. Aside from that, it's actually dictated by the attorney, not by us. So that paragraph only applies if we're holding the earnest money.
Right. And do we put a 0 in there then for the shall be paid to the escrow agent?
I would put an NA in there because because we're not the escrow agent, so we can't really dictate that. And you don't want to put, if you put a number in there, then that may come up later in a dispute that they have with the escrow agent.
Okay.
Transaction costs. So this basically is a description of what the transaction cost for each side is. The part to focus on this one is on the second paragraph where there are the 2 boxes that are checked off. So this is where I was talking about earlier: certificate of assessment, capital contributions, any working capital, stopple fees, or anything that they have from there. It specifically states here who's going to pay for it. And if you don't check that off, then it will be billed to the transaction on the seller, for the seller's transaction cost. So it's super important in this one. There's really no hard and fast rule on who should do it. I think it's the person who basically doesn't back down. Seller's going to want the buyer, buyer's going to want the seller. I've seen them both. I've seen 50-50 on whether or not it's the buyer that's done, the seller that's done. Here's where you could get in trouble though, or not in trouble, but here's where you can get caught. The the second one, which says capital contributions. What we're seeing now is, let's say you get an offer, and let's say it's an offer like, Jenna, you guys live in Nellyfield, right?
Yeah.
Okay. So when you bought in Nellyfield, there was no capital contribution.
No.
Right. However, and so when you get an offer and I sit down and say, well, Jenna, we've got an offer, they're asking that you'll pay for any of these costs. And you look at it and say, well, we don't have capital contributions, or, the estoppel fees are minimal. So let's not negotiate that, just to keep our negotiation bandwidth to a minimum. What we're seeing is a lot of times that Jenna has not been involved in the HOA, and the HOA has recently added a capital contribution. We just had this on a listing of ours. They specifically said, we don't have it. Or actually, no, we caught it because they said, you know what? They just voted on it. We're not sure what it says. So let's put it to the buyer side just in case. And they did. And luckily they did, because it would have been about a $1,200 swing for the seller on there. So again, that kind of goes back to what we talked about on page 1, where you want to make sure you confirm that with your seller, that there is not one, and with their HOA. So where you get that as the seller representative is in your listing consultation, right? When you're onboarding them as a new listing client, that should be your checklist. Item should say confirmation of no contribution fees, working capital, or any fees to be paid at closing.
Okay.
Second part just talks about if the seller is going to be paying any contributing anything to the buyer's the buyer's closing costs. This used to be either a percentage or a dollar amount. They're just asking right now for this to be a specific dollar amount. Mm-hmm. And that's when you have a first-time home, or not a first-time home buyer, you have any home buyer that wants to kind of keep cash on hand and ask for the seller to contribute to their closing costs.
Yeah, we just sold a house in December where, we got full listing price, but they wanted $5,000 towards closing cost.
Right. Not uncommon.
Right. That's where we put, hey, when you get a full price offer on day 2, you take it.
Right. Well, and the other thing is too, just as a side note on there, when you go, when you're pricing a property and you're going on a listing presentation, you want to kind of look at what's been happening in the comps, and the sold comps will tell you whether or not the buyer or seller contributed towards closing costs. It's on the bottom right-hand side of the MLS page. And you want to kind of go through and say, Mr. and Mrs. Seller, out of the 4 closings that we're using as our comps, 3 of them actually contributed anywhere from $3,000 to $5,000 in closing costs. Mm-hmm. So I just want to make sure you understand to prepare yourself that we may get an offer asking for that. Doesn't necessarily mean that we have to give it. It's all a negotiation, and sometimes you can raise the price to cover it as long as it's reasonable and you're staying within what you feel it'll praise. But just understand, be prepared for it. Mm-hmm. I'll be honest. It hasn't happened in the last probably year and a half. I went through a stint a couple of years ago where every seller, I feel like every seller I listed in I think it was 2017. I feel like every one of them, when I did the needs analysis, all of them were like, I'm not paying a dime to the buyer's closing costs. I hear that that's what's happening right now, and it doesn't make any sense to me. If they can't afford closing costs, they shouldn't be buying a house. Okay, well, let's get that out of your system, right? Because at the end of the day, that's fine. But let's use your example. If you got an offer $5,000 less than full price, would you take it?
Absolutely.
Well, sure. Okay, well then you should take full price paying closing costs, right? Mm-hmm. It's the exact same thing. So sometimes you just have to explain. My point is don't assume they know, because a lot of times when people bought their house, they would, or even if when they bought it, it was a different time. Some people don't understand at all financing closing costs, because now you're paying interest on closing costs. So it's just make sure that they understand it's probably going to be asked for. Doesn't mean they have to say yes.
Mm-hmm.
Joseph?
Yes, ma'am.
Talking about closing costs, I've heard different things from different agents. Is it standard for 2% of the sale price, 2.5%, or 3% of the sale price on the buyer's side to ask for closing costs? Which amount is your rule of thumb, or Lynn's rule of thumb, actually?
It's not much more. You typically don't see much more than 3% of loan value. Because it will actually be of the value of the loan.
The value of the loan.
Yeah. Again, the best thing to do is obviously confirm with the lender. Hey, what do I need to be asking for? But typically it's 3%, and that's a lot. I mean, if you think about it, you got a $300,000 loan. That's $9,000.
Yeah.
That's and a lot of times they can't find that amount. Now, there's different schools of thought on how the new contract was written. Is if they don't find that amount, then can you really just give them a credit? Most lenders or most attorneys, when they're writing it up, will just put however much they agree to pay towards the buyer's closing costs as a credit to the buyer from the seller. But I would say anywhere from 2 to 3%, but I would also just, double check with the lender on that one.
Thank you.
As a listing agent.
Who's playing Las Vegas chips out here?
Huh?
Somebody's playing with Vegas chips. It sounds like.
Yeah.
No?
Not me.
That might have been me making some noise. I think my microphone is super sensitive to everything.
But it did sound like somebody with 2 chips in their hand.
Mhm.
Oh, interesting. All right. So financing, again, this is more of a fill in the blank. The big thing you want to look on here is if you jump down to this part right here, buyer shall apply for financing by X date. That doesn't need to be more than 2 or 3 days.
Right.
And unless it's a Friday night, obviously give them till Monday at noon. If they're buying a house, their priority should be going and putting in applying for the financing if they haven't already done so. This whole ambiguous statement here, delivered to seller notice of reasonable pre-final approval by X date. No repairs required prior to this notice. This we used to default to closing to say. However, I know a lot of people are pushing up a little bit more because they want it done sooner. Problem with doing it any sooner is it says right here, it specifically states final loan approval occurs when lender funds loan. Great. So, it's that. So this kind of helps a little bit from the listing agent standpoint, because it's saying, well, I didn't get pre-final approval, or you gave me pre-final approval, but this right here says final doesn't happen until it funds. If it doesn't fund at the last minute and they've done everything up until that point, is the buyer really in default of the contract? Well, then that issue becomes, why did it happen? Did they go buy a car? did something come up he didn't disclose or something along that lines, and we have to deal with that on a case by case discussion. If the buyer chooses to change their lender, they can, but they have to notify the seller within blank calendar days of doing so. So if, Jenna's representing a buyer, we put in an offer, and then they realize they get a better deal with Keller Mortgage and they switch to Keller Mortgage, that's fine, they can do so. However, the next sentence specifically says you can't change the lender if the closing date agreed on in paragraph 4 is changed as a direct result. So it's kind of a if and sort of thing. You can change the lender if it doesn't change the date. But if you change the lender and it changes the date, then you can't do so without the seller's approval. So again, that often depends on when it happens in the transaction. Happens 2 days into the transaction, they say, hey, we need an extra week. Probably not a problem. Happens 3 weeks into the transaction, the day before closing, they need another week. That's probably going to be a problem. All right. Repair procedure. Well, let's just say repairs. Paragraph 8, our favorite. So there are 3 ways that this can go: repair procedure, due diligence, and as is. We're going to work backwards. We're going to start with the easy one, which is as is. You're buying this house. You have signed, you're buying. You can get it inspected. You can do anything you want with it. And you can find out it sits on a fault line and you still have to buy it. Okay, it just is, this is something that you're willing to take the risk for whatever reason. I did not think we would see as many as we already have on this. I think what people are doing is they're going as is to win it, but they're doing it with an earnest money level that they don't care if they lose. And so they're risking their earnest money. Here's the challenge with that. This is a binding contract to purchase a home. This is not a binding contract to do performance for earnest money. So if someone comes in and says, great, I'll say as is, but if I don't want it, I'll just walk, they can keep the $1,000. The challenge is that the seller has now taken their house off the market. They've started to move. They made whatever life decisions based on this. And then the buyer backs out. They could be exposed to more than just the earnest money. So it's just important to explain that to them. So that's from a buyer standpoint, or from a seller standpoint, like best case scenario. Look at me, they're buying it regardless. Then you move up to due diligence, which starts at the bottom of page 3. Due diligence basically says between now and whatever date you put here at the bottom of page 3, that is when I'm going to do any and all inspections. I'm basically going to do everything that's listed on page 4. I'm going to do all inspections. I'm going to deliver any requests for repairs. I'm going to then either move forward under the contract because we amended it based on the repairs, or I'm going to purchase it as is, or I'm going to terminate the contract, all before the date at the bottom of page 3. Okay, so everything has to happen within this one date. There's no subsequent dates or anything like that. It basically just says between now and next Friday at 6 p.m., all of these have to be done. And
how long are you giving? So like on this, let's say today's a Wednesday, are you giving them till next Friday, 9 days? Or are you giving them a week? What's your rule?
I'd be honest, right now,
now's a different situation.
Well, correct. So if it were not the current situation, I still think next Friday would be still kind of that. You'd be fine for the end of the day next Friday. Today's Wednesday. Yeah. Once you get within that 1 week period, though, because you have to understand that not only do you have to get your inspector out there, you then have to get the report. You then have to submit the report and any requests. They have to then do their research to see whether or not they're going to honor the requests.
Right.
So just keep that in mind. So now I'd be prone to give 2 weeks. I don't love that from a seller standpoint, but right now, if we're having to schedule things around everything that's going on, it may be needed. You can always beat a deadline, right? You can always get everything done before a deadline. And quite honestly, the repair request or repair addendum removes this due diligence ahead of time. You can give it 2 weeks and have it all taken care of within 7 days, and the contingency is removed. So you can always beat a deadline. There's no guarantee that they'll extend it. And then we go back. So we're progressing in favor of the buyer and the seller. So we're in seller's favor here, and then we progress to, or actually buyer's favor here, I should say, and then we progress to seller's favor here. Because due diligence, like I said, when I explain due diligence to my sellers, I simply say, look, don't pack. Don't do anything until we get out of due diligence.
Are you taking it off the market?
You have to.
Okay.
Because it is a
under
contract or a home
It's under
that's under
contract.
contract.
Yeah.
Yep. There is some lobbying off the, just to side note, there is some lobbying right now with the MLS to have an option that says under contract, still showing because of due diligence, just to give that one extra step for people to look for. But right now, honestly, if it's under contract, very few buyers are going to go look at it.
What about
All right.
under that? There was the fee. What fee are we putting in there? Like if they walk?
Okay, good question. So right now we're not seeing a whole lot of fees. We're maybe seeing a couple $100. There's some people who argue that they're putting in a termination, as from a seller standpoint, they want a termination fee similar to earnest money. I haven't really seen any buyers agree to that. That's kind of defeats the purpose of having due diligence. We want an area that's out. We are starting to see a couple more fees that are up, getting close to $500.
Mm-hmm.
Understand that the fee's not delivered until it's terminated.
Right.
So it's, and that can be paid out of the earnest money and the earnest money release, or just paid to them if there is no earnest money. So for now, from a buyer's standpoint, I'd try to get away as little as possible. And from a seller standpoint, we're trying to push to say, hey, that's fine, but we at least want a $500 termination fee. If you're going to go forward and get us to take it off the market, we at least want that.
Yep.
There's no real standard yet. I do think we're going to start to see it creeping up, though.
Mm-hmm.
All right. So the first part of paragraph 8 is now the repair procedures. So in a nutshell, basically, this is pre-negotiated repairs. Okay. What this is saying is that you'll have inspections done before the date here on the second line. Any request necessary to put these systems only, which is basically, as it says, heating and air, electrical, plumbing, water waste, to be in operable condition, the roof free of leaks, any environmental concerns, and to make improvements to make it structurally sound. If any of those need to be addressed, then the buyer needs to let the seller know. By this deadline above. Sorry. So the inspection's done, and then the notice is given by this date above.
And is that our 9 days again or so normal? Ooh, we lost you.
Say that again.
I said, is that going to be about the same thing? 9 days, 2 weeks. Joseph, we lost you.
Present. All right, I'm back. How about now?
Still a little, say something?
All right, hello.
You're still a little messed up.
And we can't hear you either.
That game.
So good.
I know. I think it's something about 3 o'clock.
All right, how about now?
Better?
Talk, Joseph.
Maybe.
No.
No.
Yeah, how about now? Is that? Oh, no. All right. Yeah, all right. It's been acting up here. How about now?
No.
Oh boy. All right.
I
All
wonder.
right. Can you guys hear me now?
That's good.
That seems better.
Okay. We'll keep pushing through because they've got the 3 o'clock call that they're going to be jumping on. So if we don't finish, can you hear me?
Ah, we lost you again. I think we lost him.
I think
Yeah.
he's gone.
Yeah.
I'm going to jump in on a 3 o'clock training, so I'm going to bug out of here too,
All
kids.
right.
Y'all stay well.
Okay, you
Okay,
too.
take care.
Yeah, to be continued, right?
Yeah, I think so. So when you did your agreement, what did you put in the other day as on the seller side?
You talking to me?
Yeah.
For which part?
Well, just like what did they wind up doing, the buyers? Like, is it due diligence or repair? Or
They did repair procedure and they had the inspection yesterday,
okay.
but they backed out. Did you hear that?
No.
No. So they did the inspection. Inspection was fine. But the buyer got cold feet because I don't think he realized how much he would have to pay in closing costs.
Oh,
So we're back on the market. I had a bunch of showings today, so we'll see.
did you do them or did you virtually?
No. I didn't do them at all. The other agent went and showed it.
Oh, they did. Okay. Now, is your mother-in-law living there or?
No, it's empty.
Oh, okay. That's good then.
Yes.
So
Yeah.
they can get in and look.
Right. Oh,
Okay.
do we need to jump off?
Huh?
Do we need to jump off, Vince?
Oh, are they on? Somebody else is on?
Vince just showed up. You're muted.
How is everybody?
Hi, good.
Is this the end of the contracts class?
Yes, it is.
I love it. I literally I had 2 minutes between calls, and I was like, oh, I wonder if Joseph's teaching that contracts class still, because I just jump into calls from here and there. But how's everybody doing?
We're doing good.
Good. We're talking about my listing right now. Yes.
love it.
I had a contract on it, but the guy got cold feet, so we're back on the market. So,
That's gonna happen.
yeah.
That's gonna happen. Just keep your head up and on to the next. Some will, some won't, some wait. So what? Who's next?
Right, exactly.
So
Yes.
keep grinding. Well, it's good to see you guys. If you need anything, call us.
Okay, I will. I gotta run. I gotta go get my little boy.
See you
All
guys.
right.
All right, I'll see you later.
Okay. All right. What meeting's coming up now?
I have no idea. I can't keep track. There's so many.
No, that's the problem.
I know.
And then we got the office ones, then we got the regional ones, then we got the national ones.
I haven't done any national ones. I just can't right now because I'm trying to, figure out this stuff. I don't know what I'm doing yet. Just day by day.
Well, we got to get in touch anyway. But did you start doing that whole thing with the 5-day train? Are you doing the 5-day training on command yet?
No. What is that?
Well, that was a thing where every day you have to do something else in command.
Is that Ignite
No,
next week?
No,
Oh,
no.
no, I'm not doing that.
Yeah. We got Ignite starting next week too, right?
Right. I figured that's why I'm trying to get some stuff in my database, and so I'll have something to do with it next week because that's what I'm told. We have to have a database with some people in it. Like I haven't called people. I haven't connected yet.
No, that's what I got. I know I'm going to get tomorrow morning. I have my thing with Adrian in the morning. So.
Was the goal setting?
Yeah.
Oh, it's not much. It's good. It's easy.
Good.
All right. Well, let me go.
All right.
Good
We'll
to
talk.
see you.
Okay. Take care. Bye-bye.
Bye.